Good morning to all of you. Andariki Shubhodayam. Welcome to Legal Matters by Sai Babu Sukara. This is my continuing first video after coming back to India. The topic is reference by the President of India to the Supreme Court and the hearing of the same by the Supreme Court and certain comments made by the court as well as the advocates, famous advocates like Harish Shalve, we are going to discuss here. Of course, the matter did not end here. It will take some other days. Actually, during interaction with some students, I could understand that you are able to grasp the present scenario, but you are not able to interpret the same, or you are not able to collaborate the same with the constitutional provisions. ప్రెసిడెన్షియల్ రెఫరెన్స్ అనగా ఏదో వచ్చింది సార్ పేపర్లో చూసాం, అంతవరకు తెలుసు, కానీ ఏ ఆర్టికల్కి ఎలాగా అనేటువంటిది లేదు. సో therefore we are going to discuss that. Actually, yesterday Honorable Chief Justice of India asked Nikhil Kaushal, that is representing the state of Maharashtra, when the Supreme Court is able to conduct the judicial review on the orders or on the letter of a governor to impose the president's rule, letter written by the governor to the president for imposition of president rule, when judicial review can be conducted, why not this can be on the governor's rule? Why this problem has come? ఇప్పుడు మీకు కొంచెం కన్ఫ్యూజన్ ఉంటుంది చెప్తాను. So it is a problematic interpretation to be dealt with by Honorable Supreme Court of India on Article 200, that is time limit for the governors to dispose of the petitions, to dispose of the orders, or to dispose of any acts or GOs issued by the government. The present scenario is certain governors, they are withholding the bills indefinitely. Right from 2020, the matter came only for that. The Supreme Court has to intervene in the case of State of Tamilnadu versus Governor of Tamilnadu. On 8/4/2025, Honorable Supreme Court of India directed the Governor of Tamilnadu, Honorable R.N. Ravi IPS, to dispose of the pending bills. The bills were kept pending right from 2020. Now, in this connection, Honorable President of India, Draupadi Murmu ji, she has put questionnaire of 14 problems or 14 items in the agenda and requested the Supreme Court to give or to utilize the consultative jurisdiction. Now you come to the article. Article 143 deals with the advisory jurisdiction of the Supreme Court, already we told you, or the consultative jurisdiction. Article 143 deals with the consultative jurisdiction of the Supreme Court. So whenever the President of India gets any doubt on a particular thing, she can refer the matter to the Supreme Court. So this case is called as In Re, Assent, withhold, reservation of the bills by governors and President of India, special reference number 1/2025. I am telling you the discussions which took place on 26/8/2025. Right. So the Constitutional Bench, you know, Constitutional Bench consists of 5 judges. Chief Justice of India, Bhushan Ramakrishnan Gawai, then Justice Suryakant, Justice Vikarmanath, Justice Pamrighantam Sri Narasimha, and Justice A.S. Chandurkar. While hearing this presidential reference, that is 14 items, particularly regarding the time limits, timelines and procedure for granting assent to the bills as per Article 200. Now, Article 143 regarding the advisory jurisdiction. Article 200 gives powers to the governor for assenting, for withholding, or for returning the bills sent by the legislative assemblies. Of course, if a legislative assembly and council are there, by both of them. So here you have to understand that governor enjoys independent power because it's a constitutional post. Governor enjoys independent power to withhold without returning the bill to the assembly. That is, we call it as pocket veto. But this interpretation is dangerous. It can expand to money bills also. So while dealing with Article 207 of the Constitution of India article which relates to money bills, so of course they have to be produced in the Lok Sabha, Rajya Sabha or the Assembly only after assenting from the Governor Gavati, Assembly or Council only after getting assent from the Governor. Right. Now in this connection, different types of discussions took place. So first of all, let us understand what does Article 200 say. Just a cursory glance at Article 200, I am going to read. Assent to the bills. When a bill has been passed by the Legislative Assembly or other things, it shall be presented to the governor, and the governor shall declare either he assents the bill, it's okay, or withholds therefrom, or he resolves the bill for consideration of the president. Here the time limit is not given. That's the main problem. It is an independent power. The post is a gubernatorial post, the governor or president. Now, Harish Salve, a senior advocate, he stated that power to withhold the consent is fourth option under Article 200. It is independent and it is not required or not linked to required to return for reconsideration. Article 200 lo em cheptarante, if the governor shall అనేది first, second may, governor may return. If the government returns the bill and the assembly wants the same thing once again, he has no other option except to allow the same, to give assent for the same. Anyway, the law permits, Article 200 permits for withholding, for giving assent, or for reservation to be sent to the president, that too within 1 month. Later, the President of India has to offer his opinion. Now, Justice P.S. Narasimha, he said, article that is, if the governor returns or the governor withholds the bill for years together, then if it is money bill, can he do for that also? I think he can do further also, because మామూలు బిల్ ఇలా పెడితే మరి ఆ బిల్ ఎందుకు పంపడు, రైట్? So Justice P.S. if government can withhold a bill, he can withhold the many bills also. For this, our Advocate General Tushar Mehta, he cleared the air, saying that Article 27 clearly says money bills can only be introduced with the governor's prior recommendation. Right? Ultimately, Harish Sarvesar says the timeline can't be fixed because it is not there in the Constitution. No doubt, the judicially pronounced timelines in the case of Tamil Nadu as well as Punjab, they will disregard the power of the governor. So it is only a political process, it is only a consultative process that you can do it, that you cannot insist on the governor, you cannot dictate him. No doubt, the President of India has got the power, because already I told you Article 156 of the Constitution says, yes, the governor will work to the pleasure of the President of India. Doctrine of pleasure, of course, ఈ మళ్ళీ డైవర్ట్ అవుతాం కాబట్టి ఆర్టికల్ 156 కూడా ఒకసారి చూసుకోండి. సో ఎనీవే, before that Article 142 also, please remember, this is inherent powers or discretionary powers of Honorable Supreme Court of India. Now here they have discussed the S.R. Bommai case also. They said that if there is no malified intention, we don't interfere. But when there is a malified intention and you delay, then is the court not supposed to interfere? That is what is called judicial review. So, by now, you might have understood that the presidential reference relating to the timeline. సో కోర్టు వారు మీరు ఇన్ని రోజుల లోపల డిసైడ్ చేయమని చెప్పవచ్చునా అండ్ ద ప్రొసీజర్. సో ప్లీజ్ రిమెంబర్ ద రిలేటెడ్ ఆర్టికల్స్. దానికోసం ఈ వీడియో చేయడం మీరు గుర్తున్నా లేకపోయినా ఆర్టికల్ 200 అసెంట్ టు ద బిల్స్. సైడ్ హెడింగ్ అలా ఇచ్చాడు. బట్ హీ కెన్ గివ్ అసెంట్, హీ కెన్ withhold the assent, he can send it for the consideration of the President of India. ఇదేమీ చేయకుండా కూర్చుంటే విత్హోల్డింగ్ ఇప్పుడు ఏం చేయాలి? దిస్ ఇస్ ద ప్రాబ్లమ్. ఇట్స్ అ రియల్ ప్రాబ్లమ్. But the legal frame, how it has to be interpreted, but it is problematic interpretation. Yesterday, Honorable Chief Justice India clearly says, when we are able to review the orders of the President of India, why not that of the governors of a state? చూద్దాం, రకరకాల రిప్రజెంటేషన్స్ వస్తున్నాయి, ఏమవుతుందనే తర్వాత. కానీ యాజ్ స్టూడెంట్స్ యూ హావ్ టు రిమెంబర్ ద ఆర్టికల్స్, రెలవెంట్ ఆర్టికల్స్. వన్స్ అగైన్ రిపీట్, ఆర్టికల్ 200 power to assent the bills, article 143 advisory or consultative jurisdiction of the Supreme Court, article 207 money bills only after the assent of the governor, article 142 assent, that is powers of the inherent powers of the Supreme Court. So presidential reference, once again article 143. So if you know these articles, you can correlate and you can be thorough with the subject. I hope you understood it. Please read the case law and read the articles of the Constitution to enrich your legal knowledge. For the present, I am staying back. Thank you.